Hello everybody, this is Sophie from Canberra Community Law. We're coming to you today from Canberra to talk about renting in public housing during COVID-19. I'm speaking to you from Ngunnawal land, and I'd like to acknowledge the elders past, present and emerging. We pay our respects to the traditional owners of the land and acknowledge that sovereignty was never ceded. This is obviously particularly important to recognise this week as it's Reconciliation Week, and we still have a lot of work to do to make sure that justice is fully realised. So today we wanted to have a conversation with you about public housing because we've been getting lots of questions from the community about what COVID-19 means for renters, how long these measures that are in place are going to last, and they've obviously been a lot of announcements in the news and a lot of stories, but it's not necessarily clear to everybody what your legal rights and responsibilities are. So in this session, I'll be giving some general legal information, not specific legal advice about your circumstances. So please post questions, ask your questions about renting and any concerns that you might have in the comments. But if you need specific legal advice about your circumstances, then we can talk to you, or one of our other legal services can talk to you if you book an appointment. So Canberra Community Law will post in the comments now how to get in touch with us. And if you need legal advice, we can help you that way. So for the next sort of 45 minutes or so, I'm just going to run through some of the key big questions that folks have been coming to us with about renting during COVID-19. Now, there are some obvious differences between public housing and private rentals, and we're going to focus on public housing today, but I'll make it clear where the same principles apply to both. So the first thing I wanted to cover is paying rent. There's been a lot of talk in the media about a rental moratorium, a moratorium on evictions, and some confusion about what this means. So the important thing for everyone to understand is that you still have to pay rent. We all still have to pay rent. All the moratorium means is that for some particular households during the pandemic, and the legislation says in the ACT, it defines that period of time as until the 22nd of July 2020. And it says during that time, for some particular households, you can't be evicted if you're not able to pay rent because of COVID-19. So that's actually really specific. That's during a particular period, only certain households, and only if you've been financially impacted by COVID-19. So I'll go through that in a minute about what sort of households might be captured by that. In general, this won't apply to lots of public housing tenants because maybe you've already been on Centrelink for some time, and your rent is calculated a bit differently. So every property that Housing ACT rents out to tenants has a market rent, but most tenants will pay a rebated rent. So this is a rent for folks on low incomes, and it's basically a rent that housing calculates based on your weekly income. So due to COVID-19, or really any reason at all, if your weekly income has changed, so maybe you've been stood down from work or you've lost shifts, or maybe you're on Centrelink for the first time, then it's very important that you tell housing about this ASAP, because this will change what rental rebates you're eligible for. When you have a change in income, you need to submit a new rental rebate form so that Housing ACT can calculate the right rent to charge you. And so there's a form online. Someone from Canberra Community Law will post it in the comments now. And that form is how you tell housing, this is how much money I'm earning, and they will then assess that and come up with the right rent for you to pay. Another important thing for you to know is that Housing ACT assesses your income as though you are receiving any Centrelink payment that you're eligible for. This is called deeming. And so this means that if you lose your job, for example, because of COVID-19, and you would be eligible for the job seeker payment, that's the new start allowance, but you don't apply for that payment, then housing can still charge you rent as if you were receiving it. So it's really important that if you think you might be eligible for a Centrelink payment, that you then go and apply for that Centrelink payment, or you contact somewhere like Canberra Community Law to get some advice on what you might be eligible for, and we can assist you with that. Another thing to note is that, as you're all probably aware, the Commonwealth Government announced something called the Coronavirus Supplement. And this was an extra $550 per fortnight that's added to some Centrelink payments, like the job seeker payment. Housing ACT is not including this extra $550 when it calculates your rent. So don't worry about that. If you have been on Newstart or Job Seeker for a while and you've got this extra rate, you don't need to worry that housing will charge you extra rent because of that $550 coronavirus supplement. That's just a supplement that's for you to use because times are tough during COVID-19. So that's rent in a nutshell. You need to keep paying it. Housing will calculate it based on how much money you're bringing in, whether that's earned income through a form of employment or whether that's a Centrelink benefit. And you need to tell housing straight away if there's any change to your income. So the second thing that I want to cover is what happens if you can't afford to pay rent. So you have to pay rent by law if you're in a tenancy agreement and it says that you pay rent for a certain amount of rent per week, and you've signed onto that agreement, you're living in the property, then it's a breach of your tenancy agreement if you don't pay rent, and you can face eviction. So it's really important that if you're having trouble paying rent due to a change in your circumstances, or something has happened, then you need to raise this with Housing ACT as soon as possible so that you don't end up accruing rental arrears, which is the debt that you owe to housing when you can't pay rent. As I said before, if you can't pay rent because your income has decreased, so you've lost some shifts, for example, then you might be entitled to have an adjusted rebate, which would mean that your rent would actually be different. It would be lower. So that rental rebate form is really key. So you need to fill that in and send that to Housing ACT if you have a change in your circumstances. When tenants don't pay rent, so when you're unable to pay rent, you accrue rental arrears. And this is the money that you owe to Housing ACT. When you accrue a bit of that, Housing ACT are entitled to send you a letter called a notice to remedy. This is a formal legal letter. It'll usually say notice to remedy at the top, and it will have some information about it about how much money they think that you owe. It'll give you a date by which you need to pay back that money, and if you can't do that, then Housing ACT might send you another letter that's called a notice to vacate, and it will give you a date that says you need to leave the house by that time. Usually it's at least 14 days from when you receive that letter. Now Housing ACT have said they're going to stop doing this during the pandemic, so hopefully this doesn't happen to you. But if it does happen, it's really important for you to know that Housing ACT can't make you leave your house. The only people that can make you leave your property is the tribunal, the ACT Administrative and Civil Tribunal. And so if Housing ACT want you to leave, they need to go to the tribunal, and a tribunal member, which is kind of like a judge, they will need to make orders that say you either need to pay the rent that you owe, and you'll need to show them that you can do that and commit to paying that rent, or you need to leave the property. So it's important for you to understand that, so that if you get that letter that says notice to remedy, that's the first step in this process, and that is the point to get legal advice. That's the point to call Canberra Community Law or legal aid and seek some help, because that's the start of this process. If you get a notice to vacate, definitely call Canberra Community Law, but also remember, you don't have to leave. You only have to leave if the ACT Administrative Tribunal tells you to. So that's really, really important. I'll just give a plug out here to Care Financial Counselling. They're a free financial counselling service that can help you if you're experiencing financial difficulties. They're really helpful in situations that you might be facing. If you get one of those letters, they can help you draw up a budget, and they can assist you with credit or debt issues. And they're an entirely free service. So someone will post in the comments that you can call Care. Their physical office I don't think is open at the moment, but they're definitely still receiving calls. So that's what happens if you can't pay rent. Now we've touched on there what that process looks like. about what might happen if you get in trouble and you can't pay rent and housing tries to evict you. So I guess this takes us to the third question. And this is something that hopefully isn't going to happen to anyone. But the question is, can I be evicted during COVID-19? The answer to that is yes. It is possible to get evicted during COVID-19, even though there is that moratorium on evictions for renters who can't pay rent. It's definitely still possible. It's only a small number of people that are exempted by that legislation. And so if you get any of those letters that I talked about before, it's very important you take them seriously and get some legal advice. I will say though that Housing ACT have made a public commitment not to evict any public housing tenants due to rental arrears during COVID-19. So they've said that they're not going to do that. I still think it's important if you get one of those letters to seek legal advice, because a public statement isn't the same as something like a guarantee in law. Having said that though, there are other reasons where Housing ACT, and this also applies to private rentals, where they might evict you. And there's nothing that stops them from evicting you for these reasons. So it's not just rental arrears, it's not just not paying rent that can result in you getting evicted. It's also things like if you don't take reasonable care of the property. So an example of that might be, say you or some people that you invite into your home have a big party and cause damage to the property. So there are holes in the walls. It would have to be relatively serious damage, but you cause damage to the property. That could be grounds for an eviction. Antisocial behaviour or causing trouble or having fights with neighbours, that can also be grounds for eviction. Another possible ground is if you're using the house for illegal purposes. So say you were selling or distributing drugs from the household. So those are grounds that there is no protection based on COVID-19 about evictions for those types of problems. So if you do get a notice to vacate or a notice to remedy that cites any of those things, just as with the rental arrears, it's very important that you get legal advice and we can help you. But those things are things that are prohibited. They're in breach of your tenancy agreement and they are grounds for eviction. So I think I've gone through rental arrears, the other grounds that could be cause for eviction. What do you do if you get the notice to remedy or you get the notice to vacate? The answer is you definitely call Canberra Community Law or get some legal advice and we can help. If you get a notice to remedy because you haven't paid rent and you manage to pay it back within that time period, then that problem should be resolved. There should be no further action. Same if, say, you get a notice to remedy for antisocial behaviour because you've been playing music really loudly every night and you get this letter and you realise that wasn't the best thing to do and you stop playing that music, then hopefully that's the end of the matter. So a notice to remedy is designed to be a sort of formal warning that if you comply with the problem, it should go away. But if you don't, or if you're unable to, that's when the notice to vacate comes in, and you need to get some legal help before it goes to the tribunal. So that's all the negative sort of stuff. Now I want to talk a bit about what are the types of general issues that you might run into. So things like repairs, for example. What happens if you live in a Housing ACT property and you need repairs? So you have exactly the same rights as every other tenant in private rentals and the ACT to have your landlord, so in this case it's Housing ACT, to keep your house in a reasonable state of repair in accordance with the law. Oh, thanks Oscar. Sorry, we're getting some nice messages here as well. So this requirement, the requirement to keep your house in a reasonable state of repair, that's based on the condition your house was in when you moved in. So that's why it's really important whenever you move into a house, you fill in that condition report and note any repairs that need to be completed. Having said that, when we're here and now, there's a problem with your house, you need a repair, there are a few steps that you need to go through. First, you need to call the maintenance help desk. So I'll post the number in the comments, but that's 62071500. You need to provide the operator with your name, your address and your telephone number and describe what the problem is and that you need to get it fixed. It's then really useful if you ask for the work order number, which they should give you, and make sure that you write down that work order number and the date, so that if housing doesn't carry out the repairs in a reasonable time, you've got that number and the date and the time that you made the call, so that you can let them know, I made this call 2 weeks ago and nothing has happened. That's the first thing you do. There are two different types of repairs that your landlord is required to carry out. There's standard repairs and there's urgent repairs. There have been some changes due to COVID-19 about standard repairs. So the law normally says your landlord must attend to non-urgent repairs, so standard repairs. The law normally says they must do that within 4 weeks. This has changed due to COVID-19. The ACT government has approved some changes that say the landlord must complete non-urgent repairs within a reasonable period. And this is partly because of things closing and there being difficulty with accessing and social distancing and all those issues. But what does it mean to have something within a reasonable period? What can you expect as a tenant? So what the law says is that in deciding what's reasonable, you have got to think about the nature of the repair, how much access is required to the property to do the repair, and what type of hardship would be suffered by you as the tenant if the repair isn't done. You and the landlord, so Housing ACT, then need to agree on the time period in which the repair would be completed. The ACT government has made a range of recommendations to Programmed, which is the service provider, as you know, that carries out those repairs, about making sure they do things like practice proper physical distancing and good hygiene when they come into your house. So that shouldn't be a health risk to you. So the types of things we're talking about here are things like a broken internal door in your house, or a kitchen drawer that's been broken, or some damage to the carpet. It's things that shouldn't massively impact on your ability to live your day-to-day life in the house, but you do need to get them repaired. So that's standard repairs that used to have to get done within a month. Now it can be longer, but it still has to be reasonable. So that's something that you need to negotiate with housing. Remember to call the maintenance number, note the work order, and you can keep calling back if the order isn't completed, if those repairs aren't done within the time period that they say they will be. And again, if the problem persists, you can call Canberra Community Law and we can assist you with that negotiation. But definitely try those steps first yourself. The second type of repair are called urgent repairs. The law says that your landlord has to make urgent repairs as soon as is necessary, as soon as you tell them about the problem. This is the case for public housing tenants and for private rentals. The same law applies to everybody. This is still the case during COVID-19. So in most cases, this should mean that Housing ACT carries out those repairs within 24 hours of you telling them about the problem. But urgent repairs are only a specific type of repair. So they're things like a burst pipe, for example. That would be an urgent repair. Or if there's rain damage and you have water coming into your house, that's an urgent repair. Or if there's a gas or electricity failure. So you can expect, if you have an urgent repair, you call maintenance, you say, this is an urgent repair, you can expect to get help within 24 hours. If that doesn't happen, you should call them back and quote the work number, and then you should call somewhere like Canberra Community Law for assistance. So what happens if they don't do the repairs? If it's a non-urgent repair, so one of those minor, internal door that's been broken or a kitchen drawer, then as the first step, as I said, we recommend you follow up with Programmed with the work order and attempt to resolve the matter over the phone. The other things that you can do is, just as Housing ACT can send you a letter called a notice to remedy telling you to fix whatever you're doing that they think is wrong, you can also send housing a letter like that they're required to comply with. So you can write Housing ACT a letter like that and say, we want this done within 2 weeks, for example, and wait and see how they respond. And then if that doesn't work, again, you can call Canberra Community Law. With an urgent repair, I really do recommend that you seek legal advice, but the law does say that if you have an urgent repair and Housing ACT don't fix it within a reasonable time, then you're entitled to undertake that repair action yourself. But the law says you're only able to do that to a maximum of 5% of the rent of the property per year. So for example, if you pay $100 a week in rent, your annual rent is a bit over $5,000, that only lets you authorize urgent repairs to, the value of something like $260. So it's not very much money. So the reason why I say be cautious with this is that if you spend more money trying to do that repair than you're entitled to under the law, there's no guarantee that Housing ACT will pay you back. So if you've got an urgent repair that's not being carried out, do seek legal help, because perhaps we can assist you and you won't run that financial risk. Really important here, under no circumstances should you withhold rent. I know it's so frustrating if you have repairs to be done and they're not getting done, and it can feel like the only power you have is to stop paying rent, but that's a breach of your tenancy agreement. And the way the law works, it says that housing can still evict you for doing that, even if they've also done the wrong thing. So please don't withhold rent. Definitely go through those steps we've just talked about, and then call Canberra Community Law if you need further assistance. Okay. Housing inspections. This is another thing we've been getting lots of questions about during COVID-19, when we're all told to socially distance and to not have too many people over. Are Housing ACT able to come into your home? So generally speaking, same with housing and with private landlords, they can inspect your home 2 times in a 12-month period, with the exception of 1 additional inspection in the first month of a new tenancy and 1 at the very end of your tenancy. So generally it's up to 2 inspections per year. What COVID-19, those rules that I talked about that have changed, what they've changed to is to say until the 22nd of July 2020, Housing ACT is only allowed to access your home to complete urgent repairs, so those ones that we talked about before, with your written consent, or if they have an order from the tribunal to do so. So that means that if you do have an inspection booked in for during this time, so before the 22nd of July, they will be conducted electronically. So this could mean you provide housing with some photographs. Maybe your housing manager wants to do a video call where they talk to you as you walk around the house with your phone, or some other form of electronic inspections. You are required, though, as a tenant to cooperate with this. So this doesn't mean that you can just turn off your phone and not be up for the inspection. It means that you've got to, if you've got an iPhone where you can do a video, it's reasonable for you to do that video and to walk around the house, or if they do ask you for photos, that you take those photos. So you've got the right to say, no, you can't come into my house. Housing ACT are not allowed to do that during this period until the 22nd of July, but they have the right to still conduct the inspection. It'll just be electronically. So those are the big sort of areas that I thought would be good to cover today. That's sort of the basics. I've got a few questions coming in, so I might jump to them, but please keep posting your questions in the comments if I've left anything out or you've got anything else that you want covered. So we've got a question here about maintenance. It says, do you know what tenants are responsible for cost-wise? I've been told by housing in the past that you only have to pay for damage or faults that you, the tenant, cause, but I've received a bill for a fault that is original to the property. Yeah, so this is where the condition report becomes really important. That report that you fill in at the beginning when you move into the house that says, here's all the things that are broken with it, or the bits of damage or the marks on the wall, so that you can go back to housing and say, no, this problem was here when I moved in, and so I shouldn't be held responsible for the cost. So in general, you should be responsible for damage that you cause, damage that anyone that you invite into your home causes, unless it's the result of an illegal activity and you've withdrawn your consent, you don't want them in the home anymore. Generally, anything that you cause or a guest of yours in your home causes is your responsibility. You're allowed general wear and tear. So, housing needs to be reasonable, that if you've been living in the property for 10 years, the carpet's not going to look quite the same as it did 10 years ago. That's all fine. But damage that was there before you moved in shouldn't be your responsibility. The issue will be about whether or not that was noted in the original condition report. So definitely try and find the condition report or ask housing for a copy of it and have a look. And if you still have trouble, then you're welcome to contact Canberra Community Law. But that's the general principle. Are there any other questions here? Oh, that was Michelle. Thanks, Michelle. Well, I don't think we have any other questions yet. I'm just having a quick look to see whether we've received any in the messages that we should cover. No, I think that's it. Oh, no. Are we allowed pets? And what about damage by a storm? Who pays? Yeah, okay. So storm damage is not your responsibility. That's the responsibility of the landlord. So earlier on this year, there was, sorry, I'm just reading the comments and people are putting the questions through. Okay, we won't turn off the live video yet. Earlier in this year, there were some big storms that caused damage to lots of public housing properties, as well as private rentals, particularly roof damage, damaged by water coming in through the ceiling and damaging walls and floors. That is not your responsibility. That is the responsibility of the landlord. One thing you do have a responsibility for as a tenant is to contact the landlord, Housing ACT, as soon as possible and let them know. So if you have a problem, so say flooding coming in through the roof, and you let it get worse and worse and it causes more and more damage, that's a situation that's problematic because you haven't done everything you can to let Housing ACT know that you need it repaired. But so long as you come and let Housing ACT know, say you've got this problem, damage by storm, it's their responsibility to fix it. So you should definitely put in put in that request to Programmed ASAP and get them to fix it. Got another question here about what happens if when housing come for repairs, they damage my personal property. So again, anything that housing does in your property is the responsibility of housing. So if housing, damage something of yours, or even if belongings of yours are damaged, because of so say let's use the storm example. If the rainwater comes in because it's damaged by the storm, and not only does it affect the property, but it also affects say your bed, which you've bought, and the quilt and things which are yours. Housing ACT is also responsible for that damage because it's caused by a fault that they haven't repaired. It's a bit more complicated in those kind of situations to get that sorted out, and I would recommend contacting Canberra Community Law, but you can effectively apply for compensation. So that requires contacting Housing ACT and saying, hey, there's this problem which is your responsibility, repairing the roof in the case of the storm. It's damaged my belongings, or your contractor came in to fix the roof that was damaged by the storm and, stood on the bed to repair the ceilings and broke the bed. That's your responsibility. We now need you to pay us back that money that thing was worth because it was your fault that it's damaged. So you can go about trying to negotiate that yourself. That is your right. But if you don't get anywhere, definitely contact Canberra Community Law because, yes, you are theoretically entitled to compensation for damage caused by Housing ACT or caused by a repair that Housing ACT didn't undertake when they should have. What about fences? We have the back fence falling apart and large trees on the electricity lines, and possums are becoming an issue. So if the fence is part of the Housing ACT property, then it's a Housing ACT responsibility and you should let Programmed know. With the trees, again, still let Housing ACT know. They might I've just had a blank about what the name is of the folks that do trees and electricity lines, but they might get them to go and fix that for you. But you can definitely let housing know if there are trees that fall within the bounds of your property, so they're within your fence line. If there are trees that are interfering with electricity, or causing a risk of falling on your house or anything like that, that's all the realm of Housing ACT. So contact Programmed, as we talked about before, contact that maintenance line, report the issue. They have a bit longer to do it because that would, unless it poses an immediate risk, that would probably be a non-urgent repair. So they have a bit longer to do it than normal, but get that work order number and then follow it up. And it's their responsibility to do that. We've got a comment here saying that someone got charged for getting your gutters cleaned by housing, but they didn't do it. You shouldn't be charged for anything that doesn't happen. So that's definitely one to raise with housing. There's a housing ACT complaints line that you can call or email and put through complaints like that. And housing will undertake an internal investigation to find out what happened, and then they should let you know what the outcome of that is. So if they've done the wrong thing, they should refund you that money, for example, or withdraw the letter that they sent you asking you to pay for it. And then that matter should be resolved. If it's not, obviously, then again, call Canberra Community Law. But someone can hopefully post in the comments for you that housing complaints line, that email, and that phone number that you can call. Okay, there are a few questions here about insurance and builder's liability. I don't know the answers to those questions, so we'll have to do a bit of research for you and comment back a little while later. I don't want to give you the wrong information, and I don't know that off the top of my head. So we will get back to you and post in the comments once we have that info. Yeah, okay, sorry. I'm responding as if I read the question out loud. So there's a question here about a faulty phone line that neither housing nor the tenant knew about when they moved in. So presumably it wasn't noted in the condition report. Sounds like maintenance have come out, had a look. The tenant's been charged despite it being an issue with the original property. This tenant's disputed it but hasn't heard back. Great job in disputing it. That's definitely the first step. If you've disputed it, there shouldn't be any interest on the amount that you owe or anything like that. So you should be completely fine to wait until you do hear back. Do chase them. So do write in again and if a reasonable time period hasn't passed and request some further information. Once you hear back from that dispute, and they will get back to you and let you know, it just sometimes takes a while. Once you hear back, if it's not in your favour, I would then definitely recommend getting in touch with us because that is something that our lawyers can help you with. It's always good if the tenant puts in the dispute themselves first and raises it with housing and tries to resolve it. But if housing then come back and say, no, we still think you're liable, but you think you're not, because you're right, if the problem pre-existed you being there as a tenant, no one advised you of it, housing didn't even know about it, it doesn't seem reasonable that you could be expected to put that in the condition report. I don't know your specific circumstances, so I can't give you advice that says, whether or not you are liable, but it sounds to me like there's definitely something that should be looked into there, and one of our lawyers could help you. So please do get in touch once you hear back from that dispute. Louise has asked, what about things that were in the original property condition report that needed fixing and has been reported every year for 11 years but is still not done? Yeah, this is something that we hear about, unfortunately, too frequently, is problems that have persisted year after year and not been actioned. I mean, there's no easy solution to this. If you've been raising it, you've been doing exactly the right thing. This is a circumstance in which you should get in touch with a lawyer, not because we can do anything magic to fix that situation. We actually can't, but because we can potentially help you escalate it. So your rights in this are to go to the ACT Administrative Tribunal and to get it rectified through that. So remember how I talked about earlier, Housing ACT can issue you with a notice to remedy and tell you need to do something by a certain date if they think you're doing the wrong thing. This is one of those circumstances where you can do that back to them and say, no, I've asked you every year to fix this problem with my property and you haven't done it. And so the next step, when they don't do it, again and again when you've asked, the next step is to go to the ACT Administrative Tribunal and you basically file an application. It's really simple. You don't actually need a lawyer to do it, but we can help you if you'd like one. Maybe someone can post in the comments here as well a link to the ACT Tribunal website because there's a form you just fill in. If you're on Centrelink or you have a low income, you can apply for the fee to get waived. So hopefully it won't cost you any money either. And basically, then housing is required to come to the tribunal. You'll come as well. You'll explain what the problem is. Housing will have to respond, and a tribunal member will then work out what to do. And will make orders, if they think that you're in the right, they'll make orders for housing to fix that problem. It's nowhere near as formal as a court. It's designed it's designed for people without lawyers there. So don't feel intimidated and definitely have a go at doing it by yourself if you would like to. It's meant to be something that anyone can just do on their own. But if you do want help, help is here. So also feel free to contact us. So I've got a message saying maybe one more is coming in over the messenger. So I'll just wait for that. Got a question here about heating in older homes. Huge problem, totally agree. This is an ongoing issue. This is not so much a legal problem. There isn't a requirement at the moment for old stock to be re-insulated, but this is definitely something that housing have said that they're working on, and certainly with new stock that they bring in, they're working on making sure that they comply with the energy standards. But that's a good point, Oscar, and it's definitely something that we need to keep raising, because the older homes are extremely cold, which also makes them extremely expensive to heat and cool, which is obviously a big financial burden on folks living in them. So okay, I think the question that I thought was coming in is going to be instead answered by a lawyer, who's not me, as legal advice when that person contacts our service. I think that's everything for now. If you've got any last questions, thanks, Sarah. Hopefully I didn't talk too fast. I often get told that I talk quickly, but you've all been putting lots of good questions in the comments, so I just wanted to make sure I got to them all. Thanks, Louise. Okay, it seems like we've maybe got to the end of the questions there. So Canberra Community Law has posted in the comments there that tribunal link. So for the person who posted the question about the tribunal, definitely have a look there and have a look at filling in that form about the repairs that haven't been done on your property. 11 years is far too long when you think about the fact that non-urgent repairs are meant to be completed within 4 weeks in non-pandemic times. 11 years is too long. So hopefully that answered folks' questions. We're going to keep trying to do these Facebook Live sort of interactive sessions on a variety of different topics over the next few weeks, just because our office, we're all here and we're answering the phone and we're trying to provide legal advice just as normal, but our office isn't physically open at the moment. So this is one way that we can talk to you directly. Don't hesitate to call us though, and someone will book you in for an appointment with a lawyer and you can have a one-on-one session over the phone. I'll also just do a quick plug. We've actually launched a new website in conjunction with the other legal services in the ACT. And it's called canberracovidlegalhelp.org.au. We'll post that in the comments now, canberracovidlegalhelp.org.au. We've worked with the Women's Legal Centre, Legal Aid, us obviously, Care Financial Counselling, a bunch of different orgs to bring together all the legal information we think you might need during COVID-19. So at the moment, we've got information on there about Centrelink, about public housing, and we'll have information up there about private rentals as well really soon, about crime and COVID, so what happens if you breach a public health guideline and get in trouble, and about going to court during this COVID period when not everything's open and things are operating differently. So please have a look at that website. Over the coming weeks, we'll be putting some more information on there. So we'll have information about domestic violence and family law, about debts, a bunch of different topics that we think might be helpful. So have a look. It's got fact sheets, it's got videos, it's got Q&As, and if you can't find the information that you need on there, it's also got a phone number, 6218-7900, and we will then refer you to the right legal service for you. So please have a look. We're really hoping that it helps people. We know that times are very stressful, and hopefully this makes it a little bit easier. So thanks so much, everyone, for tuning in. It's been really great to hear from you and to chat with you. We'll post any replies to comments that we didn't get to, including those 2 I didn't know the answers to. And also post any comments if you have other ideas for Q&As that you would like us to be running. Okay, have a good evening. Thanks, everyone. Bye.